सर मैं रिपोर्ट हुआ
with plea of Justice Vishwas may permitted to mention on contempt application an order passed by your lordship with Justice Bhattacharya, my lord.
give it
My lord.
tell call it and inform. Item number 1.
Lord, I am appearing for the appellant. This matter, along with 10 other appeals, were taken up on 24th. Your Lordship was pleased to fix it on 14th August, my lord.
Has been
Oh, okay.
come on August.
Great.
Item number 2, 2 and 3. Due to appointment on 6th, there is one matter. The single matter was the direction was given both the matter on 6th. Accordingly, petitioner is not here.
Milord, 2 and 3, Milord, I am appearing, Milord, on behalf of the petitioners, Milord. Milord, your Lordship directed the matters to be listed on 6th, Milord. By mistake, it has come today. Let it be listed on 6th, subject to your Lordship's pleasure.
Why is being all these matters are wrongly listed? দুটো এসছে দুটো ম্যাটার এসছে দুটো ম্যাটার হ্যাঁ ঠিক আছে ঠিক আছে let's see appointment of tribunal. When did we direct that it should be listed on 6th?
6th, Milord. On the last occasion, Milord, when the matter was taken up.
On which date can you please inform us?
Lordship gives me a minute, Milord.
27 July 2026. Second. 23rd. 23rd July. Where is the order? 23rd.
Milord, the file was not available. A wrong file had come. That is why, Milord, your Lordship directed that way.
Here on 6th. List these matters on 6th.
Lordship. Lordship. I'm grateful to your Lordships.
Item number 4.
My lord, I am for the petitioner, my lord. My lord, similar type of matter, my lord, will be appear in the list, my lord, tomorrow, my lord. And in that matter, my lord, your lordships are directed to file a report by the state respondents, my lord. And in this matter also, my lord, kindly see the last order, my lord. On 18th September 2023. Similar matter, the lordships are directed to file a report by the state respondents. Same will appear tomorrow.
You are appearing in that also?
Yes, my lord.
No.
Upgradation of scale of pay, and
in that case, we have given any direction?
Yes, my lord. There is a direction to file a report, and your lordships extended the time to file the report.
And what is the writing of 15 September 23 in this case?
That was not handed over to us also, my lord. The earlier advocate and AGP Mr. Tapan Kumar Mukherjee was appearing in this matter.
As prayed, you are for the petitioner.
For the petitioner.
All right, not today.
Only not today, madam.
Not, no order, not today.
Item number 5.
Sub the copy to the department.
None appear.
Item number 6.
Malad, in item number 6, Malad, Mr. Pankaj Haldar is appearing for the petitioner. Malad, in this matter, Malad, Mr. Pankaj Haldar is appearing for the petitioner, Malad. I am instructed by his clerk, Malad, to pray for not this week, Malad.
Not this week, but this one.
Not this week.
As prayed after 1 week. In today.
Fifth August. Item number 7.
7, Malad, I am for the petitioner. I am praying for only not this week, Malad. The brief is not this week, Malad. Much obliged.
As prayed.
Item number 8.
But I'm led by Mr. Anjan Banerjee, my lord. My lord, I'm paying for not today, my lord. But can it be that direct me to serve the copy upon the other side, my lord?
Not today, we'll see tomorrow.
Okay, grateful, lordship.
Item number 9.
No, no, 8.
Item number 9. Nine and 10.
None appear. Petitioner.
Nineteen. Item number 11.
I beg to appear. But there was a direction for my lord filing reply, my lord. Opposition file, my lord. May I file my reply? I believe, my lord, I have to serve again, my lord, because of these circumstances.
You have served a copy.
Yes, my lord, I've served the copy of the reply on 24th August 2024, my lord, in my
The
office.
reply
the petitioner, my lords. I need to serve once again because of that. I have served earlier, my lords. So now the further service is required. But due to my lord, the change circumstances, my lords. So my lord, that's my lord, I pray for my lord the 15 days. Because there was a two direction. One, my lord, the application has to be filed. The application which was filed before the my lord, the tribunal, and the copy.
we have not filed it. We have
Because of that, I obtained, I could not obtain the certified copy of the original application which was filed before the the SAT, State Administrative Tribunal. There was a direction passed by your lordships.
You have to obtain certified copy.
Subsequent tribunal. Because of that, the copy of the original application missed from my brief. That's why, my lord, I pay before your lordships to kindly give adjourn for certain period. So now the matter was delisted by your lordships. In the meantime, I have collected the copy of the state application. So now, my lord, it needs to, my lord, take some time. Because of that, the copy of this application along with that application has to be served upon the, my lord, the state. This is the regarding the termination, the suspension which has been against the petitioners, and now simultaneously a criminal case was initiated. The criminal case, I have been exonerated from the discharge from that criminal case. Now till this date, I have not been the released the retirement benefit. In the meantime, I retired along with the
2 weeks.
And the delay ground which has been on the ground of delay, if your lordship is allowed to place something, then can. Initially, I came before this honorable court. The wrong jurisdiction. By an order of my Lord Justice Sampa Sarkar directed this, the court has no jurisdiction to entertain this writ petition. After my lord, the exchange of the affidavit of then liberty was granted by lord to file before the appropriate forum. I approached before the my lord, the tribunal. Tribunal found that you have approached more than 14 years, 10 years, lapse of more than 10 years. So on that ground, the writ petition is not, that application is not maintainable. So my submission before your lordships, that since my termination, the suspension which was issued by the authority concerned without having any authority of law, so that illegality can be challenged at any point of time, since this is not third party interest is involved.
Is the writing out of way 138.
Lordship. Now subsequent, I have collected with, this is, if your lordship's pleasure, then I can hand it over here in now, my lords.
Way 138 is already on record. It is
No. That some part has been missing in the way which has been annexed to the writ petition. So that's why your lordship pointed out where is the prayer portion kindly. Yes. Page 37. So that part was missing in my answer. That's why your lordship granted liberty to file a way that as I have collected. My lord, may I, sorry, my lord. 2 copy, my lord, sir, my. For the pair B in that original way, my lord, that pair cannot be placed at this stage because
Where is the High Court's order?
now kindly come to page and my lord, this kindly come to page 75. I came before this honorable court in 2018.
18.
And the matter was heard by my Lord Justice Sampa Sarkar on 20th February 2023, finally. And now may I, last para, my Lord, this is the page 17, my Lord, the last para. The merits have not been gone into, and the petitioner shall be at liberty to approach the appropriate forum in accordance with law. So then, on February, I filed the way. Well, that is there, no try. 31st of February 2023, I filed the original application before the tribunal, approach before the
31st February. There are
3rd February. It may be my oh, sorry, my lord. It has been written. That's all. Kindly see the last page. Sorry, my lord. February 2023.
So it says approach in accordance with law. Why you have come after so many years?
No. Because that wrong forum, I came before this honorable court.
That wrong forum you invoked after 6 years.
My lord, this is the lordship known section 14 of the the Limitation Act. Because there is no third party interest is involved. Here is the state. I have challenged the action of the state, the order which has been passed by the block development officer in without having any jurisdiction. So that order has been challenged.
What is your date of retirement?
I have already retired.
What is the date of retirement?
The 2024 of 30th of June 2024.
30th June
2024.
22.
4. In the meantime, because due to the pendency of that, now I am seeking only, my lord, this hearing direction, my lords. See, if the suspension order, then I am entitled to subsistence allowances.
There is a question of suspension order. There is a direction for stopping your salary.
No, without stopping of salary, it is the one kind of the punishment. The punishment has to be initiated by the authority, the competent authority, my appointing authority is the district magistrate.
So anytime you feel like you can come to the High Court.
No. I came before the honorable court as per the order of my matter, rejoining.
See, now you are repeating the same things.
No.
The question remains the same. 2012, there was an order stopping your salary. In 2018, for the first time, you approached the writ court. Wrong forum.
No.
No. Why you are saying no?
No,
What is wrong in that?
No, I am not.
What is wrong in that?
No.
What did we say that you said no?
No, I came before this honorable court in 2018. 17 course of action. I approached before the higher authority. Now, higher authority forwarded the matter to the suspended.
Why you rushed in 2017? You should have waited till 2026. What was the big hurry?
2026.
What was the big hurry that you rushed in 2017 to challenge an order of 2012? You should have waited another 5-10 years.
No, my lord, kindly
What was the big urgency?
I'll consider one thing.
What is this? We are asking, you are saying the same thing again.
I am coming. Cause of action,
Cause of action, what cause of action? Cause of action
2017.
to the order which you have challenged.
Malad, this is the first, my,
Stoppage of salary from that you are affected. Malad, why you are sleeping on it for 6 years
I approached before the higher authority.
after 5 years.
2000, Malad, that 2000,
After 5 years, now yes and no.
no, yes, Malad, correct.
So after 5 years, why you are rushing after 5 years? Wait another 5 years. That we are saying, what is the big urgency?
Malad, no, there is no,
Why not another 5 years?
no big urgency, Malad, there is no,
There is no big urgency.
Malad,
Take your own time.
I make,
Whatever you want, you should come and we should.
you allow to join, you allow to join, you allow to join, I pay before the authority.
Whatever you pay, how can you pray to allow to join?
If your lordship kindly come to,
You have been released from the office. You have been released from the office.
no, I have not been,
And you are saying no.
not released, I have not been dismissed from
It's
service.
45. What
45,
did it say? Everything you say no.
45. Malad, this is,
What it says.
yes, 45.
Read it.
In pursuant to the order dated, Sergeant Sir, additional district magistrate and the Southern Chandra Dasan is hereby released from this,
Office. No.
released from, join another office, not new office.
So therefore, you have been released from the office.
Then I joined.
And in 2012 itself.
2011, I have been released.
No, 2012 you have been.
Yes, my 7th of, by memo dated 7th of
So in 2011 you were released.
release. Then I joined new post. That is the page 46. 46. Kindly see, I have been, Malad, I released, Malad, is the, by an order dated. Malad, the by,
After how many months?
Malad, is the, I put
After 5 months.
5 months. I joined the new post, that is the Mathurapur 2. Join over to Mathurapur 2.
You have been in great haste. Immediately after 5 months you complied with the order.
Malad,
And immediately after 5 years you again challenged. Everything you are
No,
doing
no,
very,
no, that is not the
diligently.
that is not the challenge.
That is the issue we have to consider whether it is challenge or not. Your conduct has to be seen.
Malad, this is my not,
Because you don't obey an order for 5 months.
Malad, the order,
Don't challenge the order for 5 years and then you say everything should.
Malad, the page 45, in 3 years, my continuous service in Joynagar 1 block.
What is your submission? Why it should be taken up? What is wrong with the tribunal's order on delay? Give us which judgment you are relying.
Malad, this if your lordship give me, Malad, because I have to need to serve the copy.
Not required.
Not, Malad, then my lord is the,
Which judgment you are relying upon? That this approach after so many years it should be looked into. Tell us by the tribunal.
Malad, if your lordship give me tomorrow, my lord, I
Come tomorrow.
get full to lords.
Not today.
Get. So my lord, the copy which has been handed over,
Keep it.
keep it, my
Copy of the original application.
lords.
Send it over.
I need to serve because of the change.
Whatever is a pairing you can give today. If you want.
Malad, if your lordship gives,
If not, we will proceed. If we find some substance, we will direct for serving.
get,
Not then we will proceed.
get.
Item 13.
Respondents, Your Lordship. Copy and None appears for the writ petitioner.
Item number 14.
The matter of 2014, I have to serve the state. Because there's a
Let's see what is.
affidavit, opposition, and reply. This is the reply.
There is a direction.
Yes, yes, yes. This I have to serve. Copy of the reply also served. Upon the outside learned advocate who appeared for the state also.
Opposition has been filed.
Yeah, opposition has been filed. Reply also, but today I am filing. There's a direction.
Like that.
Then I'm required to serve more. Afresh. That order was 15 July 2024. And I've served the copy of the reply upon the then learned advocate for the appear for state on 2nd August 2024.
So this rejection of 2013 you have challenged in 22.
Yes, but I covered by your lordship judgment, yes. I covered by your lordship judgment, Manda. But I can give some time as a satisfy your lordship.
No, rejection of 2013.
That application, because I have
What is the date of rejection of your claim?
That was, my lord, that was recommended.
No, where is the rejection by the authority? Where is the rejection?
Direction, my lord. Kindly see page 19A.
19.
Yes. That was 19. I was selected. I appeared at the written test also, selection procedure. Then that was sent for approval. First one, page 18. Can I come page 18? Please inform Musimi Haldar. This is the Nityananda such and such who decides such and such. On 8 April 2010, repeat such and such along with all testimonials in original for a recruitment of Group C post in West Bengal Police under exempted category, most urgent. Thereafter is a type copy, my lord. Page 19. That was from the DRB. That is for the data 16th May 2021. From SRP Sialda to OCRP SRP, such and such, please inform.
So this rejection of July 2019.
Yes.
It was required to be challenged before the tribunal within how much time?
No, my lord. Then, my lord, page 21, 2019. That was rejected. That a COVID period, your losses on immediate the COVID period. My
Again, we are asking you, July 2019, nobody in the world knew anything about COVID.
I know. That is right.
So therefore, why the tribunal should have examined
that is why I satisfied, not only, but this is my submission. Then their losses were coordinated, directed the state also to file opinion opposition. And
no, all that is there.
Then I have to
still the issue will remain the same, whether opposition filed or not filed.
I said you can give some time. Only today, after 2024 is appearing.
Affidavit in reply is being kept on record.
Yes, and when you lost the recent judgment, first the brother applied. Thereafter, another first son, there was second son, as well come. Limitation as
Let's see, we'll see.
Item 15.
Item 15, I'm for the petition, but there is a direction to file affidavit, but till date, no affidavit filed, and advocate appearing for the state is no more in the panel. Now, kindly adjourn the matter for period of 2 weeks. In the meantime, I shall serve copy to the earlier order, 24th May 2024.
Yes, so what is wrong with the order? Tell us, what is the law?
My lord,
What is the, there is no issue. Only issue is
I was, yeah.
you are not given pensionary benefit
Benefit and-
because there was a criminal prosecution. Now there is an acquittal.
Yes, my lord.
After the acquittal, they have paid you. Why they should be saddled with interest for that period? That's the only thing. Which law says?
Even my lord, for that period, my lord, no pension was released.
Therefore, we
pension-
are asking you under which law this will cast a liability on the state to pay interest. Sure.
My lord, case was initiated at the on the case was initiated at the, as per instruction of the authority of my department.
Again, the issue will remain the same. Under which law there is a liability to pay the interest. Sure.
My lord, I have to then, my lord, today, my lord, I am not mentioned.
Come tomorrow.
My lord, not tomorrow, my lord, next week, my lord.
As per list on Monday. It will come on Monday. Come with affidavit and opposition.
Then I am not serving.
Not required. You show us the judgment.
And there is a direction for filing affidavit, my lord. Okay. এক মিনিট।
3rd August.
হ্যাঁ, স্যার
Item 16.
নামটা দিয়ে দেবো, নামটা দিয়ে দেবো। দিয়েছি।
This number to take.
Huh?
তবে বলবো কি বললো 3 weeks 19th August. Item 17.
On a PS. 2 weeks. Either party.
বলে দিচ্ছি 2 weeks এর ডেট 4 তারিখ দে 9/4 9/6
তুমি যেটা
4 দিন
যারা
হ্যাঁ
Lordship, in this matter, learned senior Mr. Gokul Chandra Chakraborty is appearing on behalf of the petitioner. I am humbly praying for a passover. He is on the way.
कितने से क्या तो ठीक है तो ठीक है ये सारा सारा ठीक हाँ हाँ 1.3 और बाकी ये পার্টি দিয়েছে আর পাঠিয়েও আজকে দিয়েছি আবার বলেছি 2 ঘন্টা পাঠিয়ে নাও স্টক স্টক খাচ্ছে তারিখ এই 4 তারিখ করে 6 তারিখ
Item number 19.
None appears for either parties. 2 weeks.
স্যার 12 12 হুম 12 না না
Item 20.
Remote.
Item 21.
Public Service Commission.
I'm praying for a week's accommodation, my lord.
Why, sir?
Matter has came up after a long time, my lord, in the list. The matter has came up after a long time, my lord, after in the list.
Let's see.
And the accommodation.
Any steps are required to be taken?
Impugned order is at page 791, Lordship.
As paid list after 1 week. It will come after 1 week, yes.
August.
Finish the vote.
As paid by writ petitioners council.
Item 21,
21.
22. Item 22.
For a time. Pardon.
Item 3.
My lord, Mr.
23.
Chattopadhyay is engaged in courtroom number 1. I'm praying for short passover, my lord.
No, my lord, I am praying for not this week, my lord, on behalf.
Let him be here, please.
Item 24.
24, my lord, Mr. Somrat Mukherjee is appearing, my lord, in this matter, my lord, for the state, my lord.
That
Only
matter,
praying for
your
not
lordship,
today, my
last
lord.
occasion directed them, my lord, to take instruction, my lord. It is their, my lord, the revision of pay, my lord. My lord, that is internal correspondence is still pending. Against that, file a original application that was pending. Against that, I came before your lordship. Kindly come to your lordship. Kindly come to some documents, my lord. Their documents, my lord. Till date, they have not taken any steps, my lord. Page 24 onwards, my lord. Page 24 onwards, my lord. Their correspondence, my lord.
What is the date of filing?
This original application, my lord. Original application was filed, my lord. Third day of December 2025, my lord. Third day of December 2025. My lord, last occasion, my lord, short, but my lord, they are only for the senior citizen, my lord, their consideration, my lord, their internal document, their authority, my lord, request to the higher authority to take steps, my lord, according.
Not asking you on merits.
My lord, so my lord, your lordship, last occasion, your lordship directed them to take instruction.
Remember, we had observed that it was not mentionable.
Yes,
He allowed them an opportunity.
yes, ma'am.
But
Yes, ma'am.
today, when he's seeking adjournment, do you want to go into the
No,
merits?
no, 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 no.
You want to go into the merits?
No,
Go into
no,
the
no,
merits.
no, no, no. I'm not going to marry.
You have asked him, considering your senior
Yes,
citizen,
yes.
let him come back with
Yes,
his.
ma'am. Yes, ma'am.
My lord, tomorrow, my lord.
Take this in next week.
Grateful.
Please remind him what is to be done so that he can come with instructions.
Yes. Yes, ma'am. Objection.
Correct. করতে হবে
Item 25.
Madam, I am paying for the respondent, madam. I'm applying for the respondent. The state administrative tribunal is vacant, that's why the matter come.
Item 26.
26, Lordship, I am paying only not today, Lordship.
Not today, yes.
Item 27.
Yes, but since there is the direction, my lord, to file affidavit in opposition, my lord, has not been filed by the respondent side. My lord, some documents which I rely upon, my lord, are required to be placed on record by way of supplementary affidavit. That's why I have-
challenge is the rejection of the compassionate appointment.
affidavit
The
rejection
rejection
was-
order is when categorically stated what is the ground for rejection. So that is the law point. Everything is written here. Rejection order to দেখাও না জজ।
When did you file the original application? What is the date? Filing of the original application.
My lord, the supplementary affidavit I required to file to
When
rely
did
on
you
some
file the original application? When did you file the original application? How many times we have to ask?
My lord, initially the
When did you file the original application?
My lord, original application was filed, my lord. That is in the year 2024.
Huh?
And the order which was passed, my lord.
When?
My lord, page 76. The order which was passed. 24.
When did you file the original application? How many times we have to ask you?
ওইটা কবে ফাইল হয়েছিল অ্যাপ্লিকেশনটা কবে ফাইল হয়েছিল কোথায় তোমার এখানে এখানে অ্যাপ্লিকেশন দেখাও না করা আছে না দাও 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 কোথায় ডেট কোথায় কবে ডেটটা কবে 25 মাইল WPS
4th August.
Item 28.
The 28th, my lord, I have for the petition.
I'm Chandri and অসুস্থ Chandri and অসুস্থ
Your lordship, kindly have a look at the order dated 17th of March.
Not this week, my lord, on
She is unwell. It has
I
been
will never said.
she's being mentioned it since yesterday. As prayed, list in the next week. As prayed by learned state advocate, list in the next week. Fourth August.
অন্য আর এক ভাষা। দেখো,
Item 29. I have the petitioner.
Milord, this is a matter which was heard by my lords. Now, the first order, my lord, your lordship had indicated everything in the first order of 24th of June 2026. Now, my lord, very candidly speaking, I have perused the petition. Now, it appears, my lord, that in the petition, there was only a prayer which your lordships will be pleased to find in prayer A, that is for directing the respondent authority to grant notional benefit of seniority in service to the petitioner from the date of the first interview. Page my lord, 14. Page 14 of the application, my lord, which has been filed before this tribunal.
Yes.
Now, my lord, I should submit to my lords, my lord, on the last occasion, my lord, this was my lord fairly submitted that so far as the entitlement of the petitioner is concerned, my lord, I find that, my lord, the provisions, my lord, which has been which is prevailing in the field, that is, my lord, in respect of Rule 37 of the Date Cum Retirement Benefit Rules 1971. My lord, I just your lordship need not, my lord,
DCRB. DCRB. Rule? Which rule in DCRB?
The Date Cum Retirement Benefit Rule 37. Here I am just handing over because
We have it.
yes. Grateful to my lords. Now, my lord, there are 4 classifications. We are concerned with the superannuation pension. My lord, I should only indicate, I'm sorry.
So that we take it that your client is not interested in that offer, which we have recorded in the last.
I tell you, lordships, I had a talk with my client. Now, my lord, which I am indicating to my lords, my lord,
Yes,
indeed,
yes.
4 dates, nothing more than that
Yes.
is required. He was appointed on
Correct.
then the date of birth is 4/7/1971.
Yes.
Now, service on 31/7/2021.
Yes.
Now, one significant feature of the matter is special petition which was filed by the state of West Bengal before the Honorable Supreme Court against the order passed by a division bench of this court, because my lord, the division bench presided over by my lord Mr. Justice Kollanjyoti Sengupta, as his lordship then was pleased to direct that condemn the particular height. Now, these particular my lord authorities were bound, because if I would have been the authority, I would have also filed a special leave petition. Now, then, my lord, it appears, my lord, that the special leave petition was dismissed. This date of dismissal is 21/2/2012. Now, his contention is, the contention of my client is that my rights stood crystallized from 21/2/2012. Now, I have a right to pay for national service benefit 21/2/2012. I am not paying a benefit at this stage from the date, my lord, when the judgment was passed by the division bench of this court.
So instead of 19/3/12, you want it from 21
I'm grateful.
to 2012.
Grateful. Now, my lord, your lordship may only I say, my lord, that the particular, my lord, I will be attaining the age of superannuation. You have kindly note the date.
31st July 31.
Yes, I'm grateful to my lord.
Yes.
Now, then, my lord, it appears, my lord, that on the date of superannuation, I will be rendering 19 years, 4 months, 12 days. I have calculated, they have also calculated, I have also calculated, it is actually, my lord, 19 years, 4 months, 12 days.
Based on which date?
Based on the date of my appointment.
19 years?
19 years, 4 months, 12 days.
So it will be 5 months up.
Yes, there is a short, I'm grateful to my lord. This is the only thing.
So what difference it will make to you?
Because of the particular pension. This,
No, that pension will
because
increase.
a person who gets the pension treating this particular period, your lordship knows, my lord, that the date of the particular pension is fixed on the basis of the particular last pay drawn by the particular employee.
So an increment comes in between.
Yes.
What is the date of annual increment?
My lord, that I am not in a position to advise, my lord, at this stage, but I say, my lord, that
no, therefore we are trying to understand there is now the dispute lies in a very narrow compass. 21/2 or 19/3.
Yes.
So less than a month is in dispute.
No, I will wish there is a shortfall of, my lord, just 1 second, my lord.
There will be a shortfall of
7 months, 19 days. কোর্টের মধ্যে নাটক ছবি there is a shortfall of 7 months, 19 days. Now, my lord, it's a great privilege, my lord, that I get, my lord, by reading the brief and, my lord, coming to my lords, my lord, I find that, and this also came to my knowledge after I had read it, not before that.
Condonation, provision for condonation.
Not condonation, provision for relaxation. My lord, I'm just handing over.
No, that lies in the governor.
Yes.
That lies in the governor. We have seen that.
Yes.
So that for that exercise, the time is immaterial.
No, I say,
But is vested with the discretion to condone any amount. But otherwise, the rule contemplates a condonation of 6 months.
6 months.
So within 6 months, you will not fall either way. Even if 21 to 2012 is taken, you will not.
That's the reason I say that if I have to take the particular stand of the particular provisions, then I get ousted because of excess of 6 months.
So that excess of 6 months will be either way. What we are saying is,
yes,
if you want to invoke the discretion of the governor under Rule 4,
yes,
whether it is 21/2 or 19/3, it doesn't make a difference.
No, I say, my lord, that I have taken the instruction because my batchmates who were to be, my lord, who were given appointment pursuant to the particular Milord, interview which was scheduled to be held
In
on
94, August 94,
I'm grateful to my lord.
when you were arrested.
Yes.
Yes.
And I was arrested on a ground
That
which
you
was not
I
proved.
have seen it, yes.
There was no happy ending of that.
No, but nonetheless, there was a
Now,
criminal.
Milord, I cannot be faulted by an action of the authority. I get Milord slammed by both way. This is the only thing I indicate to my lords, because I have told my client that you are entitled to the particular pensionary benefit, but what slab you will be getting, that will be determined by the court.
We cannot determine. See, what we are trying to understand is what is the big difference to your case, whether it is 21 to 12 or 19.
Whenever I complete 20 years, then I get a higher amount. That may not be particular, it is for the state authority, may not.
Even if we accept 21 to 12,
Yes.
as you are canvassing, neither you will complete 20 years, nor you will come within the 6 months for seeking a condonation under the rule.
Yes.
There is no change. Now we ask you whether an increment will accrue in between. You don't know the date of annual increment, so we are not in a position to ascertain that also.
Milord, on instructions, I am submitting that,
July.
Milord, this increment comes in the month of July.
Normally, that's why we are saying how it can be. Between
I cannot say that. Milord, I say, Milord, whatever instructions are.
Therefore, we are asking, normally the date of annual increment is July, 31st July, or in some cases there are 2 dates, fixed dates. So 31st July does not fall between 21-2 and 19-3. So there is no loss on that account. Neither 21-2 nor 19-3 will enable you to seek a condonation treating your period of 6 months. In either case, you will not come within 20 years. So what is the dispute for?
I say, Milord, I would be given the benefit. I would be given the benefit of 20 years because I was faulted with by not permitting me to appear in the appointment. And Milord,
Therefore, 21-2, then there is 21-2 is not the issue. Then you want it from August 94.
No, I don't. I told you, Lordship, that I will not be paying for. I will not be paying for the benefits which the past benefits that I indicated to my lord.
Understand that
Notional benefits are there are 2 ways.
So you want the benefit from August 94?
Yes.
The notional benefit from August 94.
No, I do not even want that. I want only in respect of the pensionary benefit, which my counterparts will be getting.
You want it to be counted as qualifying service.
Yes, that is only
Let us see how you can sustain your claim. Show us the judgments. Then we are back to what we had recorded on 24/6/2026.
Yes.
That is the case we are considering.
Yes,
so we had asked you to come with the judgments. Which judgments you are relying?
Just
that because you were in a criminal case, that period delayed your joining, therefore you will get that period as a qualifying service.
Yes.
Let us see.
Now, Milord, your lordship may kindly consider that.
And this period is how much? 16 years.
Approximately.
No, it is 12 years.
12 years.
12 years.
From the motion.
One thing more, just one.
More than 12 years.
The thing, Milord, which I told you, lordships.
It's 18 years, not 12 years. 18 years.
94 to 2012.
Milord, there is a memorandum. This is a. Your lordship, kindly see paragraph B, Roman 2 of this memorandum. Achha, sir. Kindly see, once a government employee has rendered a minimum qualifying service of 20 years, pension shall be paid at 50% of the last basic drawn. For government employees who at the time of retirement have rendered qualifying service for 10 years or more, but less than 20 years, proportionate reduction shall be made while calculating the amount of pension. This is what I wanted to.
That is not the issue. Issue is under which law you can be given a benefit from August 1994
Milord, I
Because-
say, Milord, that
On any ground, whether it is a qualifying service, notional benefit, any benefit for these 18 years can be given to you because you were in a false or wrong criminal prosecution. And that delayed your joining.
Milord, just one second. If my lord, Milord, please takes into consideration the judgment of the division bench, which starts at page 58.
You filed a judgment in the writ petition.
No,
Page 58.
Page 50. Milord, this is the judgment which has been delivered in my case.
Oh. This is a judgment in contempt. So where is the original order? It is for compliance of which order?
Milord, this was, there was the disobedience of the order dated 27 January 2008.
Yes.
Passed by a division bench of the court.
Where is that order?
Supplementary take. Supplementary affidavit take to me. Milord, your lordship's Milord will be, Milord, I prepared a supplementary affidavit, but by seeing the volume of the supplementary affidavit, your lordship indicated that this need not be bothered.
This not be
Yes, yes, that's a reason, Milord. I
will go by this. It
I
has
just-
come to page
yes.
74. That is the operative part. So he was declared unfit in the
I say,
endurance
Milord,
test.
that why I am just drawing to my lord's kind attention this judgment is that how I have been penalized and non-suited on a flimsy ground, that I wanted to bribe or I wanted to give bribe to a particular constable for getting an appointment, which was not proved in the departmental proceeding.
Departmental proceeding.
Yes, departmental proceeding was also initiated, not against me. I was not in service then.
No, not in service.
Yes,
How
I was a witness. And then, Milord, there was no happy.
not a witness. You are the person who has gone to tender
Right.
the bribe.
Therefore, Milord, there was no happy ending of that particular departmental proceeding.
Therefore, ultimately, we come to the same question. For that period, can the liability be cast on the state in
Milord,
terms of
subject to
any
consider
terms?
One thing, Milord, subject to correction of my leg. Milord, liability question of the liability in my in the particular Milord jurisprudence, liabilities are of manifold types. Now, your lordship may kindly consider that the liability which I am being imposed, that I did not get appointment within a time for which I do not qualify or I cannot get the qualifying service. Can it be casted?
The point is, what is the reason?
Yes, I'm
This
getting.
question has to be answered with reference to the reason for such a delay. Now, when such a delay is founded on a criminal trial, can the
There is
state...
no criminal trial.
There was a criminal trial. He was made an accused.
Your lordship, there was no any. Kindly see, Milord, that there was no happy ending. I also inquired for my client that supply me the copy of the papers which arise from the criminal proceeding.
No, FIR was lodged.
FIR lodged. No, Milord, on instructions I submit. I take okay, that's all.
Then how was he arrested?
On the basis of a GD He was taken into custody and he was released.
Milord, on instructions, I submit, Milord, that no FIR, no trial.
Can it be, sir? He was
Milord,
arrested.
I say, Milord, but I can, what I.
Arrested. Can he be arrested without in a?
That's my, Milord, may I say one thing?
Yes.
One thing may I say? Milord, I beseech to my lords, Milord, kindly give me one more, Milord, particular, Milord, opportunity so that I can take my own frantic efforts from my office to search as to whether there are any papers lying in the office of the court, because Milord, these papers cannot be destroyed.
There is no bail, no FIR, no case.
Illegal detention, no bail. No bail, no. I was just taken in the custody, put in for 48 hours, then Milord, I was released. What is this stage, Milord, if I may?
Have you said this in the OA? Have you made such a statement in the OA?
Milord, just 1 second, I just.
Already you ascertain this fact. You ascertain this fact. You look to any other records if there are any.
I think, because before I make a statement, Milord, I am always Monday, Milord, Monday, I Monday monthly is this, sir. Monthly list, no, kindly give me the 10 days time so that in
Next Monday,
get food.
as prayed.
Relaxation this is a general relaxation.
10th August.
नहीं मैटर अल्टीमेटली सुप्रीम कोर्ट जाके क्या बेग আমি ওকে না নিয়ে যাব ফ্রি অফ সার্ভিস দেবো
Item 30.
grateful
To pursue your lordship's direction, my lord, we are filing our affidavit. The opposition, I have served the opposition, my lord. This is the reply, my lord.
You are filing a reply. Are you filing a reply?
Lordship, copy. Lordship will kindly keep it tomorrow, my lord.
No, then we'll keep it in the next week. The land AGP is unwell.
Yes.
So we are adjourning all these matters. We'll take it up in the next week.
Next, my lord, lordship will be fixing a date.
Obviously, yes. For filing a reply, we adjourn the matter. Give the date of Thursday.
I have served the copy, my lord. Let it be recorded.
Copies are already served on the learned state advocate. Wednesday, Thursday, any day.
Oh, yeah.
31.
31, my lord, I happy for the petition. Lord, your lordship, kindly have a look at your lordship's last order. Lord, dated, my lord, 15th of July.
That's resignation.
Absolutely, my lord.
Yes, yes, I have gone through that. No, I have nothing to say. I have.
You have got, the order has been issued.
Yes, yes.
No, my lord.
The rejection order has been issued.
Rejection has
Yes,
been.
my lord, there's rejection. There was brought to the notice before the learned tribunal, my lord, and it's also brought to your lordship's notice. But that is at page, my lord, page 80, my lord. But they have taken 3 points. One
points have already over.
1 month's notice, my lord, the bond. And the third is you remain full-fledged absence from 7/8/2022.
7/8/22.
After tendering resignation, she did not join the service.
What, that is the date of his application for resignation.
No, my lord, it's not right, my lord. Lord, on that day, my lord, I asked for leave. My lord, because of my familial condition, I asked for leave. My lord, leave
This
was
starts
not
from a transfer.
Yes, my lord, I've been transferred. I joined that place. I joined them. I was working. But
Yes.
thereafter things go sour, I may say. My lord, then I applied for leave. My lord, leave was not granted.
my lord, I was facing my problem, my family problem, and my children's problem. My lord, the leave was not granted.
You are a doctor?
I'm a doctor, my lord. So, my lord, I stopped going there, my lord, and my salary was stopped from that very day.
Oh.
Salary was also stopped. But thereafter, my lord, I have tendered the resignation. This is not the day, my lord, the resignation.
What is the date of your resignation?
My lord, 1st of January 2025.
25.
And it was received by them on, my lord, 7th of January 2025.
After remaining unauthorizedly absent for more than 2 years.
2 years. That's true, my lord. That's true. But which is,
And it's not a case of resignation simply, sir. You are a doctor. We don't expect this from you. We have been passing orders in all these cases. But such conduct, whether it
my lord,
can
you
be...
lordship, kindly have a look, my lord, at page, my lord, the response to the rejection order at page 81, your lordship, kindly answer. I tried to give reasons.
No. Reasons will not justify abandoning your post like this. You have to serve the public. It is for healthcare. For more than 2 years, you don't like a posting or it's inconvenient, so you will stay away.
No, I joined that place. I've continued there for a pretty long time. It's not that, my lord, the very next day I entered resignation. It's not the case, my lord. I went there, I joined there, I continued there, my lord.
What continued there? You never worked there.
No, my lord, I've continued, my lord. That is on record.
No, just see, it says from 7/8/22.
Yes, my lord.
What is the date you joined there?
Yes, I'm just coming, my lord. My lord, just give me 1 minute time, my lord.
So 2 years, 5 months already. What is the date of your joining at that new place of posting? At Jhargram.
Yes, my lord.
Jhargram is far from Kolkata. How far is it?
My lord, it's nearing, my lord, I say Jharkhand. It's nearing Jharkhand. Or may I say Purulia, Jharkhand is more near to, my lord, Jhargram than, my lord. I would say after Jharkhand, my lord, it's, my lord, Manbhum district starts.
Oh. So bordering with Jharkhand somewhere.
Yes, my lord.
What is the date on which?
Yes, my lord.
What date you joined there?
My lord, I'm just coming, my lord. সঙ্গে সঙ্গে please.
So no action was taken against him? Yes, sir. Any action taken against him for this unauthorized absence? No. So what is the date?
My lord, I may say, my lord, I am wrong, my lord. It's 6th of, it says I was transferred to Noagram, SH Jhargram on 6th, 6th of August 2022.
Exactly. So you went, you joined, and then you left.
That's my lord. What is there?
For about 2.5 years, and then you say you want to resign.
My lord, subject should kindly, my lord, your lordship has already set down the law.
Lord, what to do about these 2 years, 5 months? You tell us.
Well, I will be claiming nothing. Well, I'm asking my resignation from that very day. I'm not seeking anything.
With effect from 7/8/22.
Absolutely, not.
Where is that application from your side?
Well,
to give the resignation
well,
with effect from
51, page 51. My lord, page 54 is the, my lord, the annexure that I have to annex, my lord. Your lordship will find page 54. That is point 12. Page 54.12, my lord, that is in the rejection part also they have mentioned.
No, you are claiming it with effect from January 25. How can you get it from?
No, your lordship, can it takes up page 54 once? 54. But that is the annexure with regard to, my lord. There are two difference, my lord, subtle difference between MES and HS. But this is HS. Your lordship, annexure 3. Like just to annex with the resignation, point 12.
Why you are indulging in such well, I don't know what to say. Come to page 52, third paragraph.
I honestly hope and believe that your good sir will consider the issues mentioned above and according to the release order would be issued to be with regard to accepting resignation with immediate effect.
With immediate effect.
Well,
This you are writing in January 25.
Well, it should not have been immediate. Well, I may say it's my fault.
How can you get it? You cannot get it. If you forego all the benefits from 7/8/22, they will consider.
Well, I forgo, my lord. I will not be recorded. I will forgo everything, my lord. I won't be asking anything, my lord, from.
You file an application afresh.
Before them, my lord.
Yes.
On
Nine, it is 32, 19th August.
I'm for the petitioner, led by Advocate Shami Mohammed. I'm led by Advocate Shami Mohammed. He is now engaged at court one. So I'm praying for not this week, Lordship.
In court one, let him come tomorrow, not today. Yeah. No.
Item 34.
So I'm appearing for the university. I'm praying for only not today. Only
What happened?
Our senior Mr. Amitabh Chaudhary has not come court.
Not today only. Not today.
My lord, 20th July, it is here, so 20th July, as a petitioner in person, I already appeared. And that is
copies have been given. Copy has been given.
I already.
There was a direction to the advocate on UGC to serve a copy. I don't know whether he is given to him.
No, I have sent as a secretary UGC and also chairman, 15 party. I don't know. I already sent and also submitted, my lord, affidavit in service also, secretary to the University Grand Commission, New Delhi. And
some Mr. Anil Gupta was appearing.
Yes,
for, where is he?
I don't know.
Mr. Gupta is engaged in 422.
Do you have copies?
Then I think, Lordship, there is need to be.
I have also one copy also, my lord. But I already, my lord, I already just sent secretary.
Understood. We have understood what you are saying. You have sent the notice to the respondents. There is a service that you have submitted. We are appreciating that. But the copy is not with the lawyer. So you can give him. They will get a copy done.
That will be.
But my lord, it's a university advocate already promised on that day, 20 July, that he also spare copy also, because university also 3 parties also, and he, my lord, he already he promised just send that copy to the UGC advocate on that day. He already promised.
Who promised?
That university advocate.
No.
That he will give copy to UGC.
Huh? No promise. That is no.
No, here is a 20th July.
No such submission was made. Like
No, because
no, Lordship.
Because I already sent as a head office university UGC.
All right, let's see what is your matter. Proceed. Proceed.
My lord, actually, there is.
What is this?
That is a non-accreditation as well as affiliation. It is a state affiliated university. That is department is a DODL, and that is DODL. It is a really very sensitive department because in India there is no that type of name DODL. It is totally. It should be treated as DDE, Director of Distance Education. It is not the DODL, and as per University Act, there is no mention that is DODL, and lot of that is infrastructure facility. There is no infrastructure facility. That is, there is no library. There is no laboratory at all, and only on science category they also pay per candidate 40,000 master degree.
Who are you?
I am in introducing myself. I am a former director of DODL University, because
what is DODL? This
DODL, that means Director of Open and Distance Learning.
Yes, you are a director.
Okay, that is former director, because I also protested so many illegal activities and also corruption without tendering the purchase the materials, scientific materials. So that time I already informed to the secretary to the Government of India, Ministry of Finance. So that's why I already terminate. It is a very sensitive, but actually at present on that time that affiliation also that, but that huge officers, especially finance officer, as well as the register, they already manipulated. They already manipulated data and information, and also send several. So at present there is no affiliation as well as accreditation since 2021, and innocent students, they already cheated by the authority of the University of Kolkata. It is really very painful in the age of globalization. I also noted and also organized seminar, conference as well as workshop also. And there is no mark sheet and certificate. There is no indicate that is regular mode or distance mode. There is no mention. My lord, kindly see page number 51 as well as 57 to 58.
Yes, sir. Good. About that. লিখেছিল অর্ডার শিটে অ্যাসাইন বলে অর্ডার শিটে লিখেছিল কি করেছে? কেন লেখা থাকে ডেটাতে হ্যাঁ হ্যাঁ গল্পটা টেক্সট ফাইল হবে মানে কিছু লেখেন আর কি করে দেখবো ফাইল তো পাঠিয়ে দিয়েছি এই ফাইল চেম্বার থেকে এসছে অ্যাসাইন লেখা আছে অ্যাসাইনটা দেখ স্যার নেই I
Yes, which page you want us to see?
Actually, my lord, kindly see that is a page number is 51, and it says that is NAC accreditation. NAC accreditation, that is it is from 2021.
Yes. Yes.
That is a NAC that actually already lapsed since 2021. And as well as UGC affiliation since January 2026, MA, MSc program, but still also running. My lord, kindly stop the functioning, because the for benefit of the education society as well as legal society in the age of globalization. My lord.
My lord, copy still I am not getting. Copy of the
How many times he will give you a copy? If he has already sent the notice, why he should give you again?
I do not understand, my lord, but
You have to
I
understand.
have requested my learned friend, my lord.
Why he should give you? He is appearing in person. He has already sent a notice. You get it from your client. Why he should give you again?
Can it be taken, my lord?
It
2
is
p.m.
really so painful.
What is this?
2 p.m. or
Time is
tomorrow?
money.
Last day we had indicated to you that you do it between yourself, whatever you want to do.
Not.
Again, the same thing you are saying.
Then, my lord, tomorrow may be taken up, my lord.
No, no. It is not possible. To the time level.
Come to page 57.
And 57.
Yes.
That is, it is my RTI. I also just sent a copy to the UGC.
What does it say?
Actually, that is based on the records available in the UGC, that is a University Grant Commission. That means is a Distance Education Bureau. And by its commission order file number 21-78/2020, date number 3, dated 5th August 21, copy attached, conveyed to the University of Kolkata, where recognition was granted for a period of 5 years, academic session beginning July 21, revised as November 21 to 25 to 26, up to January 26 only.
Yes. So this is
with the following criteria. But still, on the basis of advertisement, innocent students, they already cheated. There is no, that is affiliation as well as accreditation. There is no affiliation and it is also treated as state affiliated university.
No, but this
and that is that the department they already there is it is highly offensive. They already violated rules and regulation. The UGC as well as in the age of globalization. Actually, it is really so painful. Innocent student, what is their future, my lord?
Please read again what it says. It is valid till which date?
That is 20 up to 20 with the following programs: Master of Arts, Bengali Master of Arts, English Master of Arts, History. January 26.
So it is not 21. It has been
21. That is, my lord. That is a NAC. My lord, please see. That is page number 51.
Page 51. Yes.
My lord.
No, NAC is an accreditation.
It is not because
not
my lord. No.
It is a accreditation by some standard checking authority.
No. My lord, I already assimilated in my body. I already assimilated. I know the fact and figures. That is no problem.
But there is
from my side. My lord, that is a 51. That is, I also sent a letter addressed to the director NAC by way of email, my lord.
If there is no accreditation by NAC, you want us to understand or you want to say?
No.
If you just want to say, keep saying all day.
No. I understand.
You carry on.
No. I understand.
We are trying to ascertain some things from you. If you are not ready to respond, you keep speaking. One side.
My lord, please say.
This NAC accreditation, even if it is not there, is that essential for imparting education?
No. Because it's a NAC, it would be required.
Is it essential? Without it, it cannot be done. Without it, the university cannot function.
It should be.
Again, we are asking you, without it, whether a university can function or not.
No.
Where is that provision? Show us. Where is that provision that it cannot be without NAC accreditation?
No, that is already it is also state affiliated. That is NAC accreditation is mandated.
Where is that provision that NAC accreditation is mandatory? Please show.
No. Because my lord, it's a NAC accreditation is mandated. I already noted, my lord.
You may say we are asking you to show where it is mandatory. Under which provision it has been made mandatory? Under which law it has been?
2000 under section 26 1F.
Where is that?
And it's a G of the UGC Act 1956.
Where is that provision?
My lord, it's a first page, my lord. I already noted. That is a 0 page.
0 page.
My lord, bottom. What's that?
What is HEI? What is HEI stands for?
HEI is hard education in India.
Where is the regulation? Where is it? Shows the
Regulation actually, no, regulation, my lord, it is 576 pages.
No, we are relying on one regulation. We don't.
My lord, please, it is a section, my lord, it's under section 26 1A.
Where is that provision? Please show us. You have an
Just send net computer. My lord, you just UGC Act 1956 under section is 26 1F.
We have not annexed the provision is not there in the brief.
No, there is no.
We have the UGC Act.
I have tomorrow.
Why you are gossiping down there? What is this?
Item 36.
36, your lordship.
Will not meet
Appellate
your
for
lord.
the
Will
petition.
not I accept for the petition.
Lordship,
Yeah, for the appeal.
I intend to pray for an affair of adjournment, your lordship. My counsel is leading me is out of station today. Your lordship keeps it any day next week. We'll
Let's see. Just please wait. Let us see.
Kindly seize the order dated 28th August 2025. Passed by the Honorable the then Chief Justice, as his lordship then was.
That's good.
The period of a deputation is over.
Period of deputation today is over. Milord, I am only questioning this wrongful reverse.
In between.
In between.
So you say there is a tenure.
There was a period.
So you are saying there is a tenure of 3 years. In between, I could not have been reverted.
And Milord, that too, Milord, in a very unceremonious way.
No, whether it can be done or not, that is the first question.
That is the subject matter.
That is the first. So what you are relying upon? Let us see why they could not have done it.
Yes. Milord, has my lord very kindly got through the order of.
Yes, unless you want to point out anything, please show us.
Please see the order, Milord, kindly once.
That's after reading the order only we are making the query. So which
they were supposed to give an answer to these queries.
That is why we are saying 1, 2, 3. Yes. Whether the post, so first thing is whether your right survives today. It does not.
Because the appellate is still lying vacant.
So as of today, no such relief can be granted.
Yes.
Only issue is whether that unceremonious exit as per your submission was sustainable in law or not. So we are saying show us whether
also the period that was for which I could not work. If something can be done insofar as.
So therefore, if we find that it could not have been done, then only that consequential issue will arise. Otherwise, such issue will not arise. Therefore, the issue remains whether it could have been done or not.
Please come to. They have used an affidavit apropos this order.
That is my phone ringing with the order. I am sorry. I'm so sorry. Hey. Every day I switch it off. I don't know.
They have filed this affidavit. They have served upon us on 24th September 2025.
No, this deputation is under which provision? And what is the provision governing this deputation? Yes. Its continuance or its interference?
First document.
There are provisions for premature reversal.
Yes. Now, please come to 63.
You are deputed to the board.
This is the relevant transfer on deputation. This is the Ministry of Personal Grievances and Pensions. Page 63. 17 June 2010.
Yes.
Please see page 64, paragraph 3.
Director Technology.
Yes.
Technical.
Technical.
Technology and technical.
That is the post.
So what is the date you were deputed to that post?
Lord, I was deputed here. Lord, first of all, this is a apropos selection process initiated by NGB, the National Jute Board. The selection document is at page 49, 12 June 2018. The notice inviting applications, to which I responded. And this notice for deputation, I was originally working in the Air Force. I've gone back to my parent cadre, but this was circulated. I made an application at page 54, that is 17 July 2018.
His lordship has a bench. So we'll have to break this bench right now. There was an administrative meeting of
Problem.
urgency, we were
I was
required.
expecting that it will be a holiday for us.
But I am filing the list of dates.
ডাকু কাগে এইগুলো
Item number 48
অনেকটা
and 49.
Meet, please, Your Lordship. Now, this matter was practically hard out long back, but because of change of guard, they felt difficulty. Now, my lord, I am just prepared, my lord, short list of dates just for recollection of the Honorable Court what had happened. Did you? Sorry, the last date is important, my lord, to be very succinct. That these were the issues which Your Lordship, my lord, according to us, my lord, we were able to, my lord, satisfy Your Lordship conscience that they were working in sanction post, they are qualified and eligible. The appointment is governed by the AICT rules, and they were selected by, my lord, open interview of an advertisement. Now, I will just add one judgment which has come out very recently and pat on the point. That is what 2026 5 Supreme Court cases. Because other judgment I had cited, no, I am not repeating that. Jago and followed by my Dharampal and others. I am not Dharan Singh. I am not repeating that, but this judgment has considered all these judgments. And 321. This starts from page 321. I am just relying upon the important paragraphs. চুপ করে বসো। Mallory, kindly come to paragraph 37 of this judgment. But I do not know whether it will tally, but the paragraph begins like this. The part-time contractual instructors.
39, paragraph 39.
I am told that is paragraph 39.
39 here.
Yes. May I just read out, my lord?
Yes.
The part-time contractual instructors or teachers appointed in primary schools of the state of Uttar Pradesh in the first place ceases to be contractual teachers as soon as the contract period of 11 months initially entered into or the renewed period, if any, comes to an end. It is noticed from the counter affidavit that the original contracts were last renewed on 1718, and in this renewed contract, the honorarium agreed upon was rupees such and such. There was no renewed contract thereafter. The contract having once expired and not having been renewed specifically and reduced to writing after 1718 would not actually be a contract, so as to recognize the instructor teachers so appointed to be contract teachers on the expiry of the above contract. They would rather be treated as teachers simpliciter. Then next paragraph might be paragraph 40. There's another reason to treat them as teachers on a par with other teachers. The part-time contractual instructors teachers appointed in upper primary schools possesses the basic educational qualification and eligibility as set out by the NCTE, which are on a par with the norms laid down for appointment of regular teachers. In this view of that matter, the part-time contractual instructor teachers appointed by the state government under the scheme are in no way inferior to the regular teachers or the assistant teachers appointed otherwise under this scheme. Secondly, part-time contractual teachers are not even part-time teachers, though they are described so. It is for the simple reason that their appointment itself, with a clause 5 of their service contract stipulates that they are being appointed with the condition that they would not directly or indirectly take up any part-time appointment or whole-time job anywhere else. The moment government prohibits the instructors from taking any part-time, whole-time job anywhere else, they should de facto be treated as full-time teachers. Part-time teachers are those who teach part-time during the day and do other work in the remaining time. However, nothing has been placed on record to show that they actually work part-time and do not discharge duties equivalent to those that are discharged by the regular teachers. They are instructor teachers who actually work full-time like any other teachers and cannot even take up any other work during the spare time. Thus, in fact, they are whole-time teachers. I am not really reading the entire chapters, paragraphs was very interestingly, but I am really tempted to read it. Just skip over next two paragraphs, then kindly come to a paragraph which begins notably. These part-time contractual teachers were discharging duties similar to regular teachers, including teaching up to 8 periods in a day, thereby performing the same workload and responsibility as regular teachers. In view of constitutional mandate of providing free education up to primary level, the state government cannot abandon the scheme and render the upper primary education meaningless as it would be in conflict with the Act. According to the nature of work assigned to these teachers is apparently of a permanent nature, the conclusion is therefore inevitable that the appointments of these instructor teachers are more or less of a permanent nature and against a post which is deemed to have been created substantively. Then the paragraph, skipping over the next one, in the instant case, all appointments of the instructor teachers were made by following the procedure prescribed under the scheme pursuant to a proper advertisement. These are identical facts in our case. In a sense, they were all substantively appointed. Maybe there is no sanctioned post, but the sanction of the post is deemed to be there as the nature of the work assigned to these instructors is of permanent nature, which in all probabilities is of a continuing nature and is not likely to be abandoned or tailed in any manner. The term substantive appointment is not so defined, but in service jurisprudence is considered to mean an appointment, sorry, my lord, not being an ad hoc appointment on a post made after the selection in accordance with the rules and in the absence of the rules in accordance with the procedure prescribed for under any scheme or the instructions of the government. Well, my lord was putting me a question whether the walking interview would be treated to be a regular process. That is also taken care of here. Therefore, once these instructor teachers have undergone the process of selection under the scheme, regardless of the fact that there existed a post, their appointments have to be treated as substantive in character. Then 47 Jago is considered. Then my lord, can we come to the next paragraph? At this juncture, it would be necessary to advert to yet another submission that has been put forth by the state. It is contended that the fixation of honorarium of this instructor is a policy decision wherein court has no role to play. My lord would be confronted with the similar argument. This cannot be accepted in the facts and circumstances of the case. The fixation of honorarium to the instructor teachers may be a policy decision, but it cannot be exercised in an arbitrary manner so as to subject the teachers to beggar. Article 23 for the first time, my lord, is really taken sheltered to by the Honorable Supreme Court. It's quite well advancement in the concept. The honorarium has to be fixed in consonance with the duties assigned to these instructor teachers depending upon their stature. Therefore, any policy decision of the government permanently fixing the honorarium of the instructor teachers for all times to come cannot be justified and approved, as periodical revision depending upon the price rise, cost of living, and other host of factors. It is always permissible to revise the honorarium once fixed, not only in case of instructor teachers, but also in case of employment of workers and laborers. Like considering all these, I am not troubling my lord with regard to Article 23, which is considered. Then kindly come to paragraph 67. It might be paragraph 70 before your lordship. It begins with, in view of the foregoing provisions.
71.
In view of the foregoing provisions and the scheme, it is evident that the instructor teachers appointed under the scheme have to be on a par with other instructor teachers, and they have to perform not only the academic duties but certain other non-educational duties as well. They are entitled to honorarium on a par with
Paragraph 65. In view of the foregoing provision.
It is evident that the instructor teachers appointed under the scheme have to be on a par with other instructors, teachers, and they have to perform not only the academic duties but certain other non-educational duties as well. They are entitled to honorarium on a par with other teachers. However, under the facts and circumstances of the case, the instructor teachers appointed under the scheme described as part-time contractual instructors are being paid fixed honorarium of and so on. I am not concerned with the honorarium. I am concerned with their regularization, which this court says it has to be done. Kindly straightway come to the conclusion, paragraph 74. I got it. It begins like this. On the basis of the above discussion, we conclude as under. The appointment of the part-time or contractual teachers, in fact, no longer remains contractual in nature once the contract period of 11 months for which they were initially appointed or the extended contract period stood expired. They were not even part-time teachers as they were specifically prohibited for taking any job. In fact, the teachers having continued continuously for over 10 years in a row are deemed to be employed permanently against deemed substantive posts. As with the passage of time and keeping in mind the continuity of work, such posts stand automatically created. But I stop here. This was the basic thing that which you have been arguing, and Lordship's query were on certain issues which I had tried to convince your Lordship. And this judgment really supports the contention which I was trying to advance. Here, the factual aspect is we have been working since 2007 on an open advertisement, having the qualification prescribed by AICTE and working continuously. Therefore, I do come under this. These are my humble submissions. Deeply
Yes.
May I take leave?
My lord, learned government pleader is there in this matter, my lord. He is in another court, my lord. If another day is given, my lord, so that he replies the query of the court, my lord.
Monday?
Monday, my lord. Grateful.
The submission on behalf. We have another matter at 2 p.m. So we'll come after that.
My lord.
Item number 37.
27 ও এটা বড় রেসপন্স এদিকে সাইড চেঞ্জ হয়ে গেল না না
এই দেখুন PM
You know, this is a case of premature retirement. It was dismissed on jurisdiction ground and not on merit by the Honorable Reed Court and Honorable Appeal Bench. Then I went to and filed a SLP before Honorable Supreme Court, which has ordered that this should be heard on merit.
No.
And it was allowed, my lord, in last hearing. Subject matter of this application is that part jury and implementation of the order dated 27/2/2024. By mistake, it has been typed as 26, but that has been taken care in the affidavit in opposition. It is 27/2/2024. The order was for two specific documents, my lord, but not given. The order is in the file and also in the compilation of documents. A compilation of documents was ordered.
Where is the order? You have filed it in this. Is it there in the opposition?
No, it's not.
27 to 24 order?
It is everywhere, my lord. It is in the opposition. It is in my
Which page?
opposition. They have not given me. They have given me mail, my lord. So it was given yesterday. I could not print it. Mail পাঠিয়েছে কিন্তু কালকে বিকেলে পাঠিয়েছে না আমি so that's why I could not print it, my lord, but I have the order with me. It is in এটা দিন না হ্যাঁ.
So you don't want to file any reply to the opposition?
No, my lord, everything is there. Already I have filed an compilation of documents. Everything is in the compilation of documents.
No, we are asking you. You said that copy of opposition is not served on you.
It is served to mail, my lord. And it was served yesterday. I could not take a printout of that, my lord.
So you have gone through it.
I've gone through it, my lord.
All right.
I've taken a selective printout also, but not the annexures, not the orders.
27 to 24 order.
27 to 24 order.
This is the order.
It is in volume 1, my lord, page number 271.
Is it available in the opposition?
Huh? Yes.
This order of 27 to 24 is which page?
Turn to page 56.
কোন ডেটে লিখবো?
আজকে যেটা আপনাকে মেলে পাঠিয়েছি।
হ্যাঁ সেটা কি ক্যান্টার কথা বলছেন?
না হ্যাঁ
ওই অর্ডারটার এগেইনস্টে যে এফিডেভিটটা করেছেন সেটা কবেকার দিবি?
27 ফেব্রুয়ারি 24 এ তো হ্যাঁ সে এখানেই দেয়া আছে।
Yes. This proceeding has already traveled up to the Supreme Court.
Yes, my lord. Because it was dismissed only on jurisdiction and not on merit. It is clearly written in the order, my lord. The order says, order dated 18/7/2025 says, my lord, para 13, we make it clear that we have not gone into the merits of the matter, and it will be well open to the appellant to canvass all the grounds before the appropriate forum. It was not dismissed on merit, my lord, and Honorable Supreme Court says, in its order, my lord, which is enclosed with can, that this Honorable Court, Honorable Calcutta High Court, should hear it on merit.
No.
Yet it is here, my lord, the order is here. I'll just read it out.
Yes, you are referring to paragraph 12.
Paragraph 11 and 12, my lord, yes.
12.
We observe that if a petition is filed for any other grievance of the petitioner, yes, respond. So may I proceed on merits, my lord?
So how it is an any other matter? This is an issue which is already culminated in the order of the Supreme Court. So this is not another matter. You are trying to re-agitate the same thing which has culminated in the Supreme Court's order. And you are relying on an order which has any other grievance. So this is not another grievance.
So, my lord, if there is a doubt or if there is a confusion on this.
No. Where is the question of confusion?
Because, my lord, just in the paragraph 11 it is said, paragraph 11 we read, my lord, at this juncture the petitioner.
See, the apex court, whatever you are entitled to has been decided.
No, my lord.
No.
The money portion, this was not at all the subject matter of the application. So that's why when that portion was taken up, after that I pointed out that when the subject matter of this application will be taken up, and then this order was added, my lord, from 11. At this juncture,
It was added after what?
After I pointed out that when the subject matter of the application.
Why? Before this, what has been decided by the order? Before paragraph 10, what has been decided?
Before paragraph 10, it is money matter, my lord, my PF.
So just now you said money matter was not decided. So money matter was decided.
Money matter was not the subject matter, my lord. I said that money matter was not the subject matter. I have got the application with me, my lord. It can be seen.
We cannot relook into these things.
Okay.
We cannot relook.
But it is
already, it is decided by the
decided, my lord. In the order itself, it says that at this juncture, the petitioner submitted that the main reason for him to approach this court in the present petition was that a writ petition filed by him before the Calcutta High Court was rejected on the ground that the court had no territorial jurisdiction. That is the main reason why I approached the Honorable Supreme Court. It was submitted that now when the petitioner has superannuated, I was superannuated in 2020, my lord, so from 2020 it is being referred, superannuated, and the respondent number 1, NTPC Limited, has an office in Kolkata, he may be granted liberty to approach the Calcutta High Court for his grievance with regard to his termination, my lord. With regard to my termination, my lord. Regard to his termination from service, since he is settled in Kolkata.
So you filed a writ petition in this regard? As regards termination, you have filed a writ petition?
I have filed a writ petition. That writ petition was, after writ petition was dismissed on jurisdictional ground, I approached no fresh writ petition, my lord, because a fresh writ petition will again take 6 years, my lord, and I have only 6 months left. I have filed a can in the writ petition. It will be hard tomorrow.
In the earlier writ petition?
In the earlier writ petition, I filed a can, again enclosing the Supreme Court order, and I have requested for hearing it on merit.
So that liberty you have already availed?
That liberty I have already availed. And this is only on par jury. Last time it was said this does not cover reinstatement. Last time I was directed, my lord, that this does not cover the can I have filed does not cover my reinstatement. It is only about perjury and compliance of the order. So I have to restrict myself to that. So I have restricted myself here to that only.
Yes.
And now may I proceed on merit, my lord?
No, that is, so what is the perjury? Show us.
I have referred in my can to a paragraph 5 of my can, my lord, at page 3. The said perjury is evident from the compilation of documents ordered by this honorable court on 17/1/2025 and filed on 16/5/2025. I was asked to give a compilation of documents because the number of affidavits was growing so large. So I made a compilation of documents, my lord, and along with that I made a compilation of affidavits from where the documents have been taken. So I'll refer to that, my lord, and it is here. The compilation of documents is here, my lord. So may I refer to this, my lord, compilation of documents.
order of 17/1/25.
Hmm.
You are referring to an order of 17/1/25, which has ordered for some documents.
Compilation of documents, my lord. May I read out?
Where is that order of 17/1/25?
It is in the file, my lord, in this case only.
In 106 of my
Actually, there are 60 or 70 orders, my lord, going on for last 6 years.
আপনি আমার ঠিক
না আপনার চুক্তি কি করে আপনি তো বলছেন না
Yes.
And this was filed, my lord, on 16/5/2025. The next page there. No, 16/5, not the next page. The 16/5 order. 16/5, my lord. I'll just give the page number, my lord. 16/5, page number 111 of the affidavit in opposition.
Yes. Yes.
Well, two documents was ordered in this particular order, the 27/2/2024, that is minutes of meeting of PMC of 2015 and 2016. These two are audited documents, my lord. These two are audited documents. I'll just take a second, my lord. Audited documents of HR department are preserved in multiple files, my lord, in multiple locations like personal files in the project and corporate center, HR policy promotion files, and audit files in regional headquarters and corporate center. They are digitally preserved in server clusters in two different seismic zones, my lord. One in New Delhi and another in Hyderabad, and backup magnetic storage devices. Unless the whole system is destroyed for any reason, like natural calamity, audited documents cannot.
What are you reading? From which page you are reading?
I'm reading from, my lord, compilation of documents, page 55.
No, what is it?
Huh?
What is it?
This is, my lord, it is a part of supplementary affidavit on behalf of the petitioner dated 14/1/2025, page number 2, It is compilation page number 2, my lord. This is compilation page number 2.
No. See, you have said that they have committed a perjury in the affidavit. Which affidavit you are referring to? Why you are reading all these documents?
So
where is that affidavit?
That affidavit, my lord. Yes, my
We
lord.
are not here to allow you to read everything in the file.
No,
Come to that affidavit which you are saying.
Yes, my lord. That affidavit is in. I'm
There is
referring
an
to
affidavit,
affidavit.
according to you, there is an affidavit filed on 17 September. Wherein they have committed a perjury. Where is that affidavit? What is the perjury? Show us. And how it is a perjury. Show us. This is not, this cannot be made. This is to look into everything again. Earlier, you were being assisted by some learned advocate. Where is he or she?
Amicus curiae, my lord.
So where is he or she?
He said he will be coming, my lord, but must be.
Come with him. It's not possible. We can't waste all day for this. This way it can't be done, sir.
Oh, my lord, then fix a date. I'll inform honorable learned amicus curiae.
It's going to be here. Everybody is waiting for you to fish through the documents. This can't go on all day.
Amicus curiae is, my lord, appointed by this court, and he's.
Yeah, we have seen in the order. Therefore, we are asking you, where is he or she, whoever it is?
My lord, please then kindly give a date. I'll be informing him, and he will come. My lord.
Possible to go into anything like this?
Without troubling him, well, this application should be rejected outright for the simple reason of the Supreme Court order.
Let him have his say. We'll hear him. He's in person. We'll see.
Very well.
Judgment of the FX court.
Very clear. তাহলে আপনাকে কপিটা দিলাম। ঠিক আছে।
The learned petitioner.
Item 38.
Okay, respondent, I'm led by Mr. Mojumdar in this. ওগুলো বাইরে বসে বাইরেই বসে আছে ওগুলোকে
For the respondent.
I for that respondent.
Milord, in this case, Milord, a disciplinary proceeding was initiated against our AVP, Assistant Vice President Finance, Milord, who was entrusted with the duties to take over a particular company on our behalf. We are a government company, Milord, within the meaning of the Government Companies Act, Milord, and we are under the Ministry of Petroleum. Now, Milord, what happened, Milord? We, Milord, issued a charge sheet. The inquiry proceeding was commenced and ultimately concluded. But, Milord, the fact is this, Milord, that the inquiry officer, Milord, this report, we, Milord, differ with the findings of the inquiry officer's report. We, Milord, sent certain questions, framed certain questions, Milord, and that was, and we sought for certain clarifications. From Milord, the officer that from the delinquent, that this we Milord were not in agreement with the findings of the inquiry officer. Now, Milord, here, Milord, when the writ petitioner, Milord, moved this writ application, the Honorable Single Judge, after Milord exchange of affidavits, Milord, was kind enough to dismiss, Milord, the writ petition. And in paragraph 10 of the stay application,
we, my lord, elucidated, narrated, my lord, that our inabilities in appearing before the court when the matter was taken up, we are absent from the court. My lord, after that, my lord, the matter.
You were the rate petitioner. You were the rate petitioner.
No, I'm the respondent. Mr. Majumdar, my learned esteemed senior friend, had moved.
No, you said because of your non-appearance.
I did not appear on the day, my lord, when the matter was taken up.
All
So, my lord, matter was the writ petition was allowed, and my lord, in absence of my lord, the response.
Just now you said dismiss. That is the whole reason for all the confusion.
This was of allowed the writ petition.
Yes.
So, my lord, on that date, my lord, it was allowed. Now, my lord, we filed an application for recalling. The recalling was not allowed. My lord, in that writ application, in that recalling, my lord, the court had, my lord, assigned its reason. Be that as it may, we did not question, my lord, that subsequent decision, which is a sequel to the application for recalling, my lord, resorting to, my lord, the basic principles of Order 9, Rule 13 of the Code of Civil Procedure. The court dismissed our petition, application. We did not prefer any appeal. On the last day when the matter was taken up, your lordships were of the view, prima facie, that if I did not question, my lord, the propriety of the order passed in recalling application, my lord, today I cannot agitate that ground, my lord, which was, my lord, enumerated in application for recalling as well as in the appeal section 10 of the stay application. If I may be permitted, my lord, I have, my lord, made the first limb of submission to the query because I am duty bound to meet the query of the court. Why, my lord, this principle is not applicable in writ proceedings and applies to, my lord, in other proceedings, I am, my lord, duty bound to answer. My lord, if your lordship kindly takes pain to turn, my lord, section, the paragraph 10 of my application for stay, which is in line with the application filed before the Honorable Single Judge, and then I will take your lordship's attention, my lord, to this.
Can we refer to the paper book?
Yes.
The order rejecting your recall application is dated.
After the application recalling, it was dismissed by order 26 paragraph 10 of the application for stay of my application for stay, my lord, in the paper book.
If you will be kind enough to give us the page, then we may be able to find it.
425 of the order passed in the recalling application.
425
is the order passed in the recalling application. Second volume. Sorry, sir. Very bulk.
Now you are referring to para 10 of your stay application.
407. It starts from 407, para 10, 413. May I read, Milord?
Yes.
Milord. I start from, Milord, with your lordship's kind permission from paragraph 9. In the writ petition, orders were passed for executive affidavits, and accordingly, the affidavit of opposition was filed on 6 December 2023, and the reply was to be filed within 4 December 2023. The reply was filed on respondents on 4 January 2024. Copies of the affidavit of opposition reply are annexed to such and such. The petition was appeared on the list under the heading hearing, and each time the matter was taken, an adjournment was served by the writ petitioner. The petition was ranked in the list of March 2024 as per 2024, and was lastly appealed 2024.
It was there. 6. Court. List also indicated that every day hearing matters shall be taken at 3 p.m. The hearing 6 was fixed at 3 p.m. Step 4. Another 6-5 is also not a stop. Accordingly, it was unexpected that the matter shall be taken upon the same date. Sheriffs were expecting the action to be hard. Sheriffs are repeated leave the court. Sheriffs taken hard without hearing. It's a dated hard June 16. Step 2 and step 4. Yes. Paragraph
So there is no
application. But the past step 4, which was dated 6 July 2024. And was marked with level 5. The order dated Millard, that is 26 July. Which I submitted Millard. Arms of the order dated first step to respondents were absent. He happens that the first step to minutes of the case. The respondent is not an obligation for recall of the order. For recall of such order under the Civil Procedure Code and under the rules of the High Court and Rule 226 of the Constitution of India, hence application such and such time dispute resolving liberty to the petitioner to avail the law.
Apart from now, Millard, I relied on the last occasion, Millard. Yes, the copies I have handed up. The 1980 volume 4 SCC, page 680. That judgment regarding Supreme Court rules. Supreme Court rules, Millard. Not only that, Millard. This Millard, this also Millard. At the cost of tiring repetition, Millard, since your lordship recalls everything, Millard, this part, Millard, question the principle of law if you have correctly understood, Millard. Although it was passed in the context of review, Millard, the scope of review is very narrow. But even that case, Millard, the court said that is Millard, paragraph 19 and 25. Millard, this is passed by Millard, the judge, Millard, bench comprised of Justice Iyer, is Murtaza Fazal, Justice Desai, Justice Pathak, Justice Kaushal. Now, Millard, 19 and 25, I will only place my reliance on these two paragraphs. This court has said all rightly. This is in support of what submission? This submission, Millard, the importance of the argument, oral argument, only one day. Paragraph 10, Millard, I said, Millard, that the difficulties, Millard, I could not anticipate. Millard, I could not anticipate. The court said I proceeded on merit. Now, Millard, the oral argument, the importance of an oral argument in a matter, Millard, where, Millard, the hearing is necessary, the court did not consider this point of law because paragraph 19, Millard, kindly sees, because court did not go into that question. What you are trying to canvass is that even if you are not there, the court. No, I am said, Millard, even if Millard means whether my presence has to be, my absence must be justified. Millard, I said, Millard, in paragraph 10, why, Millard, this pleading? Millard, as enumerated in paragraph 10 of the petition, Millard, the court did not discuss it. But we are not here considering that recall application today. No, recall application because question here is how it is relevant in because, Millard, because I on the first day I said, Millard, the matter should be remanded back for the consideration because otherwise I will lose one forum. Remanded to the honorable single judge to decide the matter, Millard, on the basis of the pleadings, Millard, that was filed by the parties. The court, Millard, did not lend its ears to me. The court said, no, you didn't want to say anything. Because no, I didn't know. You were not there. No, I explained, Millard. Say, I don't expect you to be taking up. I'm going home. No, Millard, kindly sit. Now you say you send it back. That is the problem. No, Millard, kindly sit. Why are you relying on this judgment? We don't know. Because, Millard, the court on the, because I said. Anyway, you have relied on it, para 1920. Millard,
if your lordship kindly my lord, have the charity to consider not omit the other paragraphs also. Many times the writ petition has sought adjournments. This was not addressed.
Not the issue.
My lord, whether
See, whatever submission you advance is required to be founded on certain basic facts. Admitted facts not in dispute is you chose not to be there. For whatever reason, based on your assessment of the court's speed or whatever.
I said,
For the issue was decided. Recall rejected, recall not challenged.
Recall not challenged.
So judgment is relevant to that.
Judgment, my lord, the hearing, my lord, because I was not given an opportunity.
We are asking what is your submission? It's a
Submission of the paragraph 10, my lord, your lordships on the last page.
How can we consider it?
Last day, your lordships over. That your lordships were of the opinion on a different day.
Sir,
that
that issue is over.
My lord, issue, my lord, subject to correction. Your lordships are on the premise, the conception that if I did not challenge the recall in this case, in this court, I am prevented from, my lord, arguing the point, my lord, which has been canvassed in the stay application. To that, my lord, I have prepared a note for your lordship's kind.
No notes. What is the submission you tell
Submission,
us?
my
Why
lord.
we should take notes? We don't know what you're trying to say.
My lord,
How paragraph 10 is relevant to this proceeding?
this was not considered by his lordship.
No, the order has been passed. You have not challenged it. What is the question of looking into a reconsidered
Adding the petition, I agree.
consider or it can be considered only if you challenge the order.
Answer is yes. My answer is yes. If I would not challenge, my lord, kindly, my lord, have the charity to, my lord, give me, my lord, for 10 minutes time. I said that fortunately law is otherwise. If I can impress upon your lordship.
Yes, we don't know why you're relying on
No,
this.
no, I said, my lord, that opportunity.
We are unable to comprehend.
No, my lord, it is my inability that I could not pursue. That is the first point, that your lordship was aware of the opinion that in the event we
are doing something which is we don't know how it is going to be
because
relevant to this case.
Because your lordships were of the opinion.
See, the hard facts are your absence on the date of hearing of the writ petition. For whatever reason you may justify, you know you were absent and you were absent, therefore it was decided in your absence. You filed an application for recall. That also rejected. Now, how can we look into that recall application today?
No, my lord, this recall application, I did not prefer any, I did not question the propriety of the recalling application.
Therefore, how can we look into paragraph 9 of the application?
I said, my lord, I want to place law what is the law on the subject.
Yes.
Your lordship said that your lordship cannot look into this.
We cannot.
Yes. That is not.
This challenge, how can we look into it?
My lord, if your lordships are minded to hear me, my lord, kindly, my lord, give me.
Yes.
Because I am not conversant with that branch of law. I have tried to the best of my ability, my lord, to pursue your lordship. My lord,
we will rely on what you say.
No, I will rely, my lord, because your lordship your lordships have already, my lord, taken through the order, my lord, on the past in, my lord, the recalling application. The Honorable Single Judge, my lord, did not address the issue, my lord, in its proper perspective. The Honorable Single Judge.
Can you see?
No.
Can you say that we have not challenged it?
My
that we are asking to repeat. Your argument is you presume that it is under challenge and looking into that order.
Yes, my lord, that is unacceptable. My lord, your lordship, my lord, the first I will say, my lord, that is which of if lordship kindly takes in the Code of Civil Procedure, your lordship will be pleased to find there are sections, possibly section 1 to 158.
Yes.
These sections are known to be a substantive laws. Your lordships,
which provision we don't read the entire CPC.
I not.
Provision that even if not into the correctness of that order.
My lord, I said, my lord, if your lordship
just show us any provision.
May I be allowed to, my lord, read the notes only 2 pages now?
No, you'd show us the provision. Why notes? What notes will do? There's nothing in notes.
I kindly sees, my lord, only, my lord, 2 pages, my lord, your lordship many a times, my lord, kindly, my lord, why it is required.
How we will look into an order not challenged.
That if your lordship,
any provision you show us from any law.
I said that order. I said that under section 121 to section 151.
So in the present proceeding, you have challenged the main order.
Yes.
You have not challenged the subsequent order. This is the fact. This is the factual position.
Lord, if I am not allowed to, my lord, say, my lord, on this, my lord, kindly, my lord, allow me. If your lordship finds that this submission has no substance, that is, I am under your lordship's, my lord, guidance. My lord,
you may see why we are repeatedly, why we are repeatedly saying
this
that
point was argued. A 7-judge bench of your lordship's court had considered this in a way. My lord, why I say, Milord, if I can say, if whether I'm correct in submitting that section 1 to 158 of the Code of Civil Procedure is a substantive law, and order 1 to order 51, Milord, that is the procedural law. If this proposition of law are acceptable to your lordships, then what is the ramification of such submission in the present context?
Yes.
Right. Section 1 Civil Procedure, the High Court is empowered to make necessary amendments in the schedule of the Code of Civil Procedure, which includes Order 1 to 51. Why am I telling? Because the Order 151, the section granted CPC referred to was their substantive law. If changes to be required to do it, the same should be done by the state legislature or parliament of the country, as the case may be. Section 100 of CPC, it says that the categories of applicable order without the rejection from application under Order in Rule 13 is an applicable one, which your lordship says Order in Rule 13. Set section 1 for Civil Procedure Code, which categorically says that this procedure not rate proceeding, which your lordship said, Milord, so far that Order in Rule 13 application in essence, Milord, was dismissed. I did not challenge an appeal. This proposition of law is applicable in a proceeding, Milord, instituted in a suit, not in a writ proceeding. If your lordship, Milord, kindly have the charity to take pain, Milord, to find substance, Milord, I have, Milord, at least, Milord, gone through this provision, section, Milord, these two sections, Milord, the Order in Rule 13, kindly have a look at section 141. If your lordship, Milord, kindly, Milord, have the charity to consider these two provisions.
Yes, Order 9 Rule 13 does not apply to writ proceeding. Which is the other provision?
141. I said, Milord, that 141 of the Code of Civil Procedure says that the procedural aspect, meaning thereby,
and these provisions apply to writ proceeding. Order 9 Rule 13 doesn't apply, but 141 applies.
141, because Milord, it is my incompleteness that I could not pursue your lordship, Milord, to Milord, make your lordship, Milord, that to pursue. It is my failure that I said
proceeding.
Yes, Milord, why? Why I made this submission? If your lordship kindly takes pain to look at section 1 to 150, Milord, these are the substantive.
Correct. You have already said that.
No, then what is the ramification?
141.
141. Then your lordship's query is why 141 is why 141 is applicable and why the orders and rules are not applicable. Why this is so?
That's not an issue. No, you raised an order which is not challenged. Can we look into it?
No, because that is here, Milord, the issues are there. Your lordship says look into that. Lordships cannot look into that. Yes. If your lordships cannot scrutinize, Milord, the supervise, at least Milord, analyze the provisions, the two provisions.
A order not challenged can be looked into in an appeal.
What is that you are required? No, I am saying, Milord, that your lordship can ignore this because 141 says
we can ignore what?
Absolutely. Yes. Kindly, Milord, record. Milord, if your lordships, Milord, kindly have the charity to consider section 141.
Yes.
It may be a complete misunderstanding of the law, Milord, since your lordship, Milord, at least encourage certain, Milord, aspect, Milord. I am, Milord, confining myself. One. The procedure provided in the code of suits shall be followed as far as it can be given procedure in any court of civil jurisdiction. In this case, the explanation and expression proceedings, this procedure does not include any proceedings under Article 6 of the Constitution of India. When I come to Milord, Order 9, Rule 13.
Yes.
Milord, your lordship said, Milord, there is a provision which applies to Milord in a suit. But Milord, this
we have said nothing. We are only saying, can we look into an order to check your lordship? That is all. Don't put words in our mouth.
No, Milord, yes.
No, it is saying how you are expecting us to look in an order which you have not challenged.
If your lordships,
Immediately.
if your lordships are not minded to go into the niceties of the two different sections.
You have said 9 Rule 13 not applicable
I
to
said-
proceeding.
No, you said we can ignore no challenge to the others. 1 to 158 are substantive provisions.
No,
Now,
what is
now,
the
now,
difference?
what, how does it mean to make the my case Millard bitter?
That is what we are wondering.
Yes,
We are
Millard,
unable.
yes.
So
Millard,
now we
question,
cannot.
now, Millard, 141 is a mandate. Order 9 Rule 13 is not to be followed. Millard, it is not a mandate, Millard, which binds Millard the learned single judge while dismissing Millard this application.
How can we look
Yes,
into it?
yes, yes,
How
yes.
can we look into it? You are presuming as if you are looking into the recalling application.
No,
That is the whole problem.
My problem is that your lordships are not minded to enter into the question as to whether my non-challenge prevents me from without looking.
No, we have taken note of your
No, it is not.
What other
No,
submissions?
no.
3 submissions you have advanced.
Yeah, pleadings are there. Now, my lord, pleadings are there. Now, my lord kindly says that now এই judgment না yes না 2011 না তার আগের যেটা 1980 যেটা আগে যেটা জাস্টিস গণেন রায় দেখি This is about 3 judges bench of your lordship's court. Now, reported in 1988, SCC online, Calcutta 116, my lord.
Yes.
This was subsequently affirmed by the civil judge of the page, my lord, page 8, Calcutta 358, and 1988 SCC online, Calcutta 116. Big. So, she's got it.
Just
Considering the conventions but the civil personal code was justified. In person, civil can considering the person change of the code, should be precisely for the sake of the court said section. The court such orders and sections of the code. However, considering section 1 code such and such case should section 1 76. The law puts on so substantive right also the section sections of the courts and exclusion has been section 1 for section 76 section of specific
is a character of substitute. Simply as section in application, restoration of such a social mistakes case, if such mistakes is what victim second question special to be understood for the social such and such that dismissal. It confirms to me justice if the person status and explicit before it. Because some status case or student itself. However, I refer this argument only for this extent because section 141 and the connection, logical connection between Order 9, Rule 13 and Section 141 is limited to a suit, not in a writ proceeding. That is why the Parliament has brought about the amendment made in 76, thereby consciously excluded the writ jurisdiction, writ proceeding, and it applied to only Order 9, Rule 13, that is a suit, not here. That is why the court, while dealing with this, that I have ships are prima facie of the opinion that non-challenge to the the rejection order dated 26/2024 it creates a bar or impediment so far as my pleading which I insisting to go through this that paragraph 10. My anticipation subject to correction that is whether logical or not, whether the normal tendency of the court or the practice that when court had fixed two matters, it is not that any negligent attitude or I have acted in the matter. Number one, number two, I filed opposition. The court was on, but the argument that was only for a day, whether I am entitled to lose the forum. That is why on the first day, I mentioned after my argument, I said if the matter is referred back to the honorable single judge, at least to give me a chance to argue my case, I may lose, I may win. But at least I was unable to present. The scenario which I have pleaded, that is not stands far away from the reality. Number one, it is not unreasonable. The absence is clear. Since I cannot deny, but the question is, all failures are not seen in this world. I failed, because of the wrong anticipation. The anticipation is based on the previous comment of the court. The court possibly never but least false. Sometimes it happens. Ship's court maintain a practice. Although all courts are not bound to follow this practice, the number if the advocates do not appear any of the parties, the matter is to John your lordship takes up your lordships normally take up on the matter. But here parties are not at fault. Here categorically said that the repetition many
should also maintain uniformity with the other courts.
No, I never said so. Yes. Because your lordship, what the practice being followed, but the question here is, that certain reasonableness, in the conduct. Court, always, evaluates the conduct of the parties, its counsel, everything. But here, kindly says, is it a far-fetched, I put this question to myself, whether it is.
Yes.
If I may.
Yes. Yes.
He is saying that your lordships are hearing this matter on merit,
I have not.
No, I said,
You are putting words in his mouth, you are putting words in our mouth.
Problem is, the standing, it differs,
Yes.
He has said so. Your lordships continuously saying that how can I maintain, this application?
Can we,
continuously. I
will consider these points you have raised.
No, I
anything
say,
else?
No, anything, So, whether, this in this appeal also, I have taken a ground. I have mentioned that the court did not have the matter ex parte. Now, that is one aspect in this. Now, this judgment I have shown. The question that was referred to two questions were placed before the.
So what happened before the single judge? What happened before the single judge?
The order passed by the honorable single.
Yes.
May first order.
The order, my lord.
The order under challenge.
Yes.
Yes.
376.
Page
376. এটা ভলিউম মিলার 3.
The appeal was filed after rejection of the review.
After recalling, rejection of the recall. Yes, first we Millard made a pleading.
376.
Yes.
No, we'll just give us 5 minutes. What date he attains the age of superannuation?
Superannuation age. Superannuity.
What is the date?
Date of superannuation.
Yes.
Superannuation date টা কবে?
23, October 23.
23.
Three years have passed.
5 years.
23.
5 years. Disciplinary authorities order is of 2018.
Yes. Then it is 2018 to 26, 8 years.
5 years, sir.
23
You need not dispute everything we say.
That is why, my lord, on the last day, my lord, I was, my lord, beseeching your lordships, my lord. At least, my lord, if I get a chance and a time bound, if your lordship says, my lord, that the matter should be heard within a month.
What is to be heard? Your recalling application?
No, the matter on merit, my lord, not recalling.
That is your prayer. That is your submission.
That is one limb of my submission, because I say, my lord, that there is only one day, my lord, I missed the bus, my lord. Only one day. There is no consistent failure on my part, my lord. And the matter, my lord, the court delved into the matter. The court, my lord, was persuaded by the submission made by my learned esteemed senior friend, my lord. The court had come to a conclusion.
The punishment was compulsory retirement with the benefits.
Yes.
With benefits.
Non-pensionable service.
Oh, non-pensionable service. So what he was deprived of by virtue of the punishment order? Only the salary. Difference between subsistence allowance and salary for 5 years. No, but he would have been in service for another 5 years. And suspension was on which date?
Yes, can you? Don't suspend you. I'll give the exact date. Yes, 3rd May 2018.
Oh, so that 3rd May 2020. No, that is the date of punishment. That is the date of punishment. That's not the date.
Suspension to হয়েছিল হ্যাঁ সাসপেনশন তো হয়নি
But he was probably not placed under suspension.
No,
Possibly
proceeding was conducted without suspension.
yes that can be done.
So he got his salary till the date he was awarded the punishment.
So because I was Millard, I thought Millard that if I get a chance Millard to argue the matter on merit Millard, at least I will not lose the forum, one forum.
Yes. Anything else?
No, and if your lordship, then Millard, the question of merit, Millard, why this? And because the court had proceeded, if your lordship go through page 376, the judgment, the reasoning, the court had analyzed the matter. The court had answered, Millard, that in these conspectus of facts, Millard, what should be the law? The court said, Millard, I do not sit in the appeal, but court considered, Millard, from paragraph 5, 6, 7, certain, Millard, factual aspect. And Millard, what is there, Millard, where from the court has found this thing, Millard, and what are the documentary evidences? Page paragraph 5, 6, Millard. Kindly, it starts its journey, Millard. The paragraph, it says, Millard, that it says the petitioner were directed to look into the book of the accounts to elicit values of valuation, consequently the quantum of money such and such to take over between February till August 20 following facts. Now, this is Millard, the 28th February such and such, the senior vice president, finance director of finance required the petitioner to upload opening balance of the VDPL.
Can you show us the charge memo?
Seven. Need start from Millard, page 36.
Yes. We have seen.
Yes. Now, my lord, your lordships, on the last occasion, my lord, that whether service rule, my lord, were placed. The two, my lord, rule 28, 26, rule Roman 5, rule 9.
So what is the, let us hear the other side also.
Yes, my lord. Only
regarding the effect of dismissal of the review. Then we'll proceed.
Yes, my lord. Yes, my lord. And I omitted one thing, my lord. The question that were my lord, put before the referred, that will be whether invoking provisions of section 141 of the code and application on rule 4 or rule 9 of the code can be made set aside for dismissal for the default of an application on order 4 might happen of the code. When such application is maintainable, what should be the limitation for such application? These are the point, and my lord, at the cost of time and reputation, I submitted only once, my lord, that order 43 rule 1 dealt with section 104, which of the orders that are appealable under the code. And order rule 13 proviso is also there. That is why.
Yes, what is the effect of if the recalling has been rejected?
This was in fact heard on merit by the Honorable Single Judge. His Lordship categorically observed that if you can satisfy me on merit that the order requires warrants a recalling, I shall recall my order. It was heard for 45 minutes on merit as well. Unfortunately, it has not been reflected in the order. But on merit, the other side was heard while hearing the recalling application, while considering the recalling application.
So what we are
not there, I'm told.
Huh?
Is it being denied?
No, it is denied by my judge.
No, we were.
She can file an affidavit.
No, not required.
No affidavit.
No.
Let us not go into that. Order 43.
We will only go by the order as it is.
Order 43, Rule 1.
Court has dismissed it, not in your absence. Yes.
Order 43, Rule 1 makes the order an appealable order. Now, my learned friend has not preferred an appeal from the order if he is aggrieved thereby. And he has accepted the part of the order by which not the recalling was rejected, and he has preferred an appeal from the original order.
So what is the effect?
And he has to, if he wants to pursue the order, he has to thrash it out on merit before your Lordship's court. If he wants to pursue his appeal, there is no appeal from the order as of date.
From the order of recall.
Recall.
No, but if there is no appeal from the order of recall, what is the effect on the appeal from the main order?
That survives. I don't say.
Therefore, we are saying, why do you want to go into this?
That survives. He has a right to pursue that appeal.
No, because I said, my lord, at the cost of tiring reputation that I could not get an opportunity in the court below. My court
don't want to make submission.
There is one
appeal pass the order.
No, I said, my lord, that is one limb that I said, my lord, the court had a duty to consider all disputes.
So forget about it. Let us see.
Yes, my lord. Then, my lord, kindly sees after I will place first. I will place the prayer in the writ petition and the pleading. What is the challenge thrown to the in the writ? The court will not consider it, my lord. Kindly sees the page 33.
Yes. What is it? Tell us.
Reading the nature of mandamus only when the order of punishment was challenged, the question of the charge sheet was not under challenge. Kindly says, anything in the nature of mandamus responds to says aside the order dated 20th such and such shall be passed by the disciplinary authority and the review committee such and such. Writ of mandamus be issued thereby directing the respondent to instate the petitioner to the same post as he was AVP. Reading the nature of social the issue directing the respondents to produce the records. Say, adding still the operation of the order dated 2023, there is order of punishment under such and such, chairman Manalari, and the review committee order make the rule absolute and to pass such other order. If the foundation, charge sheet indicates the initiation and the commencement of the disciplinary proceedings, why charge sheet is bad? Why the charge sheet is vague or it is biased? There is no challenge thrown in the prayer. There is no challenge that the charge sheet should be set aside. Whether I am correct or justified in making this submission before this honorable court, that friend's client, he was consciously his right, knowing he had right, and this is a clear waiver. And that whether the charge sheet, if the charge sheet, the foundation of the charges, not under challenge, that what is the ramification? I put this question to myself. He has already questioned the punishment order and only the punishment order and the stay.
So, my lord,
Punishment, stay and sought reinstatement, certification of the entire records.
but
Of a certiorari.
certiorari.
Yes.
Certiorari, my lord, but he has
So now
not challenged.
therefore, charge memo not challenged, all
Challenge.
very well.
Now, my lord, whether, my lord, this is immaterial. That is the question, my lord. Now, my lord, kindly, in the PD also, my lord.
What is the charge memo? What have you alleged against him?
I alleged against him, my lord, in a sense, my lord, in substance, page 36, 37, my lord, that he was entrusted with the duties, my lord, based on his, my lord, statement, based on his email, my lord, the company had incurred a loss. My lord, that is a negligence.
No, that's not your allegation.
Kindly cease.
Please read. There is
Please
no
read
such
the-
allegation that based on his statement, somebody has suffered a loss.
My lord, ultimately in the inquiry, we have also made the difference.
Your charge memo says that there is a negligence in maintenance of accounts. In maintenance of accounts.
Negligence is a misconduct. He was.
There is no statement by him. You said
Kindly cease.
maintenance of final.
37.
Yes.
Such in such manner accounts.
Yes.
The function of such manner that it resulted in NB finance. One function of NB travel vacations and has financed the account in such manner that it resulted in
Where are you reading?
37.
No, article of charge is at 30.
The statement of mutation is a part
at 38.
The such and such corporate finance who was working with such and such for the previous year. But he is the 36, your lordship is asking me to go to 36.
38, sir. 38
Yes.
is the article of charge which is to be established in the
Yes,
proceeding.
article of charges are such and such functional travel charge of the finance of account function is we travel accounting of business. Which is a vacation exotic of private limited finance settlement was part of his official duty. You are properly responsible for roughly reconciliation of accounts, and because of negligence excess amounting, the rupee such and such was used to resulting the finance of the company.
So in the process of purchase of this VEDPL,
yes,
there is a negligence which has led to some excess payment, a very huge amount.
Huge loss, yes. Yeah, and that is an act of negligence. Question is whether act of negligence is a misconduct. Milord, I took my lord's kind attention on the last occasion that it is a misconduct. 6, acting prejudicial to the interest of the company, neglect of work on negligence in the performance of
This charge has been brought home on the basis of what evidence? Let's see. Where is the inquiry report?
Page 97 is the inquiry report.
Exoneration.
Exoneration.
97.
Yes.
So it's page 97 to 200.
97 to?
97 to.
It starts from 97.
113.
Goes up to which page?
It will not end it in.
97.
আরে জজ সাহেব জিজ্ঞেস করছেন কত 102A তাই না সোম?
All right. So then you have given a note of disagreement.
Yes.
Where is that?
212. 221. 221. May I read 221 or inquiry report?
No, 221. Let's see what you have done. Because till 221 it was in your hands.
It starts from 221A.
There are 3 volumes.
Yes. Permit me, Millard, to read, Millard. It is to be, Millard, 221. Kindly give me permission, Millard.
Yes.
This agreement, 222.
Yes.
May I start, Millard? Because then I will take my attention to the evidence, Millard, laid by the parties, Millard, and more particularly certain emails, Millard. Where is the provision? Action taken on the inquiry report?
Action?
Where is the provision, prescription for action taken on the inquiry report in your rule?
Lordship, on the last occasion, I have.
You have given us the rule, regulations.
এইটা দেখুন তো
Which provision? Thirty-two. So can you point out from the disagreement note, the conclusion of the disciplinary authority?
Millard, if your lordships kindly take, Millard, page 228.
Yes.
Millard,
This chart Millard 3.3. First one, observation dated 15/24, copy enclosed as E5, submitted by the charged officer indicates that the role of CO was not defined. The PO has not disputed the evidence or submitted any evidence. The answer that the review of the discipline with the main refer in file is a clarification sought by the charged officer is if take insurance coverage insured risk as mentioned which was required by finance. So the role of the C is not defined as 3.3 of the meter function. Sorry, sorry. Certain sector March 2024. 2024 indicated position as finance function. Vacation exotic business is the of his role of responsibility of finance and account function vacation exotic business. In view of the officer observed in his observation and conclusion that the role of C was not when it comes to the supplementary answer to the show cause. Page 4.
This has been referred to by the disciplinary authority.
Yes, but this is the first. This is the said that his rule is different, and I discovered from page 4. Because
whether he says or not, that is not material. What he says is not material. That was not before the disciplinary authority.
The record says it is.
We cannot look into those things. We have to confine to the record before the disciplinary authority.
Yes, this is a record before the disciplinary authority. Yes, this was not submitted before your lordship.
29/550.
Yes, this was not submitted. I urge your lordship granted leave them to file this reply was not given. This was not considered.
Where in this, we are just this one issue we are testing.
Yes, the first issue. He said his role was not defined.
Where this conclusion of the disciplinary authority refers to 29/5/2015 letter.
The 228 Millard.
Yes, where does it say?
Yes.
Now I'll again see, Mr. Please, Basu. You have read the provision 32? 32(2). Please read for our benefit.
32.
2.
Yes.
What is
Shall if we officer the charge of
charge? What is to be done?
record its results.
Please read.
Yes, and the charges for such. It is the findings of the sir in the charges. So the charges findings of the inquiry officer.
Record its reasons for such reason is to be recorded by recording his own finding on the charge. And how that finding is to be recorded if the evidence on record is sufficient for the purpose. Now just show us tomorrow, go through it, which difference is based on any evidence on the record.
First of all, this evidence
We are going to confine to procedure, we are not going to sit in appeal. Show us. It is 4:26, we cannot proceed today. You go through it, show us tomorrow. That the conclusions of the disciplinary authority are in accordance with the
am I not entitled to place, my lord, the reply which was given, and he himself admitted that his name was defined.
You cannot, we are not going to sit in appeal. The disciplinary authority is, the conclusion of the disciplinary authority, if founded on procedure.
No, it is based on evidence. Your lordship will not show it as so. So I am referring to what I said that his role was defined.
Whether the disciplinary authority's conclusion is founded on a piece of evidence as
Yes, it includes records. I did the reply.
as required under 32(2).
Let me let the reply.
It does.
Milord, kindly sees what
It does.
kindly sees.
It does not require him to take that into consideration. So if you take it into consideration, you show it. If not, then we don't know. It does not exclude. It is you on such material. Yes, there is no dispute on that.
If
Please read 32(2).
Yes, and 2 is
with reference to 32(2). We are not going to look into the inquiry report. It was for the disciplinary authority to look into it, relying on evidence and record his conclusions in accordance therewith. If he has done so,
for the sake of my clarity, Milord, for the sake of clarity, whether I am permitted, Milord, to respond to your lordship's query, that whether, Milord, the disciplinary authority, while Milord disagreeing with the findings of the inquiry officer, have the liberty, Milord, under this 32(2), to Milord, to consider, Milord, this particular reply,
where he did not have the liberty. It was mandatory for him to look into it. So therefore, let us see whether his conclusion was relied on this material.
Reasons also.
So any material, any evidence, you show us if his conclusions are founded on any evidence whatsoever. Why disagreeing? In 32(2). That is our scope of scrutiny, nothing beyond that.
Tomorrow at in the second half it's possible. First half I have.
Tomorrow we have some matter.
Second half, Milord.
3:30.
3:30.
If we don't have any matter fixed at 2.
Ache.
2 p.m. Friday?
Friday, your lordship has fixed another matter. My learned senior friend is appearing at 2 p.m. And
every day you have occupied, then what we can?
No, your lordship fixes. He has concluded in a way. I am.
Saturday court is open.
Saturday another matter is also other side in the justice parent teacher meeting. Schools are making Saturday, Milord. I will come, and he will also come, Milord, before Justice Mitra, Milord, court number 18. Sixth away.
What can be done?
Sixth away.
For further consideration, list on